All right, and we are now recording.
I'd like to welcome everybody to this meeting of the Law School Council and ask the staff to take a roll call, please, to determine if there is a quorum.
Susan Bachian,
Present.
Mary Basic,
Present.
Tiffany Gabrielson is not present, Christopher E. Dedan,
Present.
Devin Kenyon,
Present.
Mary Beth Moylan,
Present.
Carly Sassy.
Present.
We have a quorum, Chair.
Thank you. Next is our call for public comment. Members of the public can make written public comment submitted to the lsc@calbar.ca.gov email box. Written public comment was submitted and distributed to the council. And now verbal public comments of up to 3 minutes will be taken now, first recognizing any individuals who signed up in advance. My understanding is nobody has signed up in advance. So now you may make public comment by raising your hand using the raise hand function on a computer or by pressing *9 on a phone. Staff will share a timer on the screen during the comments.
I don't see any hands raised for public comment. We can proceed.
Thank you. We are now on to the chair's report. I just have some brief remarks. I'd like to congratulate all of my fellow LSC members on completing the academic year and best wishes to all of us and who are working with our grads on the bar exam. I am looking forward to today's agenda items. It is a wide range of topics, and I was just thinking it really demonstrates the scope of issues that law schools and the state bar have in common and take an interest in. Final words, I would just encourage people to consider applying for the Law School Council. I've been on the council since 2020. It's been very rewarding. And for those of you who are interested in perhaps being the chair, I've found it really interesting to be able to have some input into the agenda items, and it's been just a very cool experience. So with that, I will conclude my remarks.
Is it my turn to make remarks?
Yes.
Okay. I don't have a lot of extensive remarks. I will be leading everyone in a discussion a little bit later on the agenda. I would say there is a committee of bar examiners meeting next Friday. You might want to check out the agenda for that. Several things probably of interest to the law schools represented here and not represented here. So just wanted to make you all aware of that, but we can go to the next item.
Teresa, do we want to go to 3.1 or skip to something else?
I was just gonna, sorry, I don't know what happened there. I was just gonna say, let me see, I do see Tara is in the audience. Tara, can you raise your hand if you would be okay to start now? Or would you rather, okay, she is raising her hand, that is great. So we will start with 3.1.
Good afternoon, everyone. Teresa, would you mind promoting Christina as well, just in case? She also has a backup with my PowerPoint, just in case.
Yes, yeah.
Thank you. And let me share my screen. And just to confirm, you can see my screen?
Yes.
Right, so thank you so much for having me today. My name is Tara Clark. I'm one of the program directors for the Office of Admissions. So I oversee the Moral Character Department, eligibility and testing accommodations. So as I believe you are all aware, positive moral character determination is one of the requirements for admission to practice law in California. So in California, the definition of good moral character includes, but is not limited to, qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others in the judicial process. And as a reminder, here's just an overview of our application. We ask a broad range of information from the applicants, including their education, residence history, where they've worked, any contact they've had with the legal system as a participant, so civil, criminal matters, bankruptcy, things of that nature. And you will actually see, hopefully by early next year, we're in the process of updating our application to be a little bit more streamlined. So that'll be coming soon. And so what we're talking about today are the rules of the state bar related to moral character, so the Chapter 4 rules. So if you were following along, these went through quite a process. The first iteration to the court ultimately went with the practical training of law students and law office study. Those were rejected by the court. They asked for some additional changes and to ensure that we made more consistency within the rules, used rules that were defined throughout and things of that nature. You'll also see some of the rule changes. They are codify and conform to current practice. We're trying to clarify areas of confusion for applicants and then modify some definitions to be clear and more accurate. And so these rule changes go into effect on June 23rd. So you'll see we have some minor updates that we're making just to reflect the rule updates, but there's not a lot. One of the main things that we did change, you'll see the second bullet point on the left-hand side, is that out-of-state attorneys who are currently not in good standing for disciplinary reasons are prohibited from even submitting a moral character application. However, staff and the committee of bar examiners, the working group, in reviewing this, we felt that it was best to remove that prohibition to allow the state bar then to actually evaluate the conduct and also what the applicant has done since then. As many of you may know, the moral character process is not just what have you done, but it's have you been candid about it? Have you engaged in rehabilitative activities? Has there been any repeat offenses? Things of that nature. So removing that prohibition will allow those out-of-state attorneys to actually apply. And so they'll actually be able to get a determination here. And then moving back to the top one, this is not as significant, but the rules of the state bar right now for the admissions rules didn't contemplate electronic transmission. So for the moral character process, applicants have 30 days from the date of a negative determination to submit a request for administrative review. Currently, we've been building in the time for if it was mailed, even though we're emailing the decision. So now it'll just be the straight 30 days since we're sending those determinations via email. You'll also see a couple other changes that we've made. One that you'll see in the top right, and this was one of the ones to conform to current practice. So currently we send a questionnaire out to applicants who receive a positive determination. So positive determination is valid for 3 years. If the applicant isn't admitted at that halfway mark around 18 months, we send them an update questionnaire, even though they have a continuing duty to report to us anything that's changed within 30 days. A lot of the times they forget at that point. So this questionnaire kind of just prompts them, reminds them if there's anything new that they need to disclose. And then that determination remains valid for the rest of that 3-year period. And let's see. Oh, and then for the bottom one on the bottom right, so the positive moral character determination, and this is another thing to align with the current process. So positive determination is valid for 36 months, and then with the revision or until submission of an extension application. So applicants can submit an extension application, which is about half the cost, and it's less intensive. They don't have to rehash their whole history. They can just let us know what's happened since their last determination if they have not yet been admitted, and they can do that within that last 6-month period from their initial determination. And so this is just to make it very clear for applicants that if you do decide to submit at month 32 of the 36-month validity period, that's essentially going to freeze that positive determination. And so that way we can go through and look at anything new that you've disclosed or if there is anything, and then a new positive determination would be issued. And those are the highlights that I had from it. I do have a red line version if you wanted to see, but I thought that was a little bit too in the weeds. Are there any questions? And hi, Chris.
Hi, Tara. This is more maybe jumping ahead, but if it would be possible to get a copy of the revised questions that you'll be providing to the applicants, it kind of helps us advise students when they are going through the process.
Yes, so once we get closer to that, then we can definitely provide that. Right now, we are still in the process of working out a timeline with our IT unit. As you can imagine, it's, even if some things are just minor changes, seemingly it can take a bit of work on their end. So, but of course, once we get that revised application, we'll get that out to you.
Perfect. Thank you.
And Ms. Bakshi?
So I was going to ask the same question, if we could please get a copy of the questions and the order they're in as well, so that when students are working through it, we can follow along. But also, I think I may have missed it. I think you said it was coming soon. Is there a rough time frame for when we should start looking for this to change? Should we expect it to change this summer, this fall?
And sorry, so just to be clear, so the revised rules go into effect on June 23rd. The new application, we don't have a firm timeline yet because we're still working with our IT unit. We're hoping that it'll be available at the latest early next year, possibly a winter or possibly quarter 4 this year, but it really kind of depends on IT's workload and how we can build it out, the timeline.
Thank you.
There are no other questions. Christina is here as well if you wanted to move to the next item.
Thanks, Tara.
Okay, I am going to share my screen. Hopefully you can all see the PowerPoints. Thank you for the nodding heads. Okay, I am Christina. I believe I've worked with some of you. For those that do not know me, I'm one of the program managers here within the Office of Admissions. And today I am going to discuss the best practices for requesting testing accommodations for individuals with disabilities when applying for the state bar exams.
Christina,
So
you're gonna want to change the presenter
my
mode.
view. Thank you, Donna. Does that look good?
Perfect.
Thank you. So the State Bar has streamlined its process for applicants requesting testing accommodations. We have reduced the number of forms required and added a new process for requesting the same or equivalent accommodations as those granted by other testing entities. And we give considerable weight to past accommodations granted by college and law schools. A student should submit their request for TA online through the applicant portal. However, hard copy applications are also available upon request. A few tips. You may submit your request for TA before applying for the exam. Before the exam application opens, the testing accommodations application is available. It is important to note that these are two separate applications. The exam application is separate from the TA request application. And there are certain accommodations that may be automatically approved based on prior accommodations for high stakes exams. When I say high stakes exams, I'm referring to the LSAT, the MPRE, SAT, GRE, all of those acronyms. Students requesting those same accommodations for a state bar exam should upload proof of their prior accommodations. And for accommodations that do not qualify for the automatic approval, applicants must also upload our qualified professional certification form, and they may include any supplemental documentation that will support the request. I have given you a screenshot of the applicant portal just back down below on the left-hand side as an example of what an applicant would see in their own portal. They can check the status of their general request or their application. And a pro tip here would be to mention that the case must be in submitted status. You can see the statuses. You'll see pending internal review, drafted and verified. There's other statuses as well. I have to point out, though, that verified and drafted does not mean the application has been submitted and sent to staff for review. I've seen it happen where an applicant starts the TA application, but then they leave it in drafted or verified status to come back to it later, and they forget to submit the application by the deadline. Different types of accommodation requests. Initial requests, of course, are those requesting accommodations with the state bar for the very first time. This would include both permanent and temporary accommodations like pregnancy or lactating. Expanded requests. These give the applicant the ability to modify their request for accommodations if testing conditions change, or if there are functional limitations due to their disability changes. An emergency request may be submitted by the applicants who become disabled after the final filing deadline. For example, someone breaks their arm within a few weeks of the bar exam. This does not apply to disabilities that existed before the deadline, whether or not the applicant was able to see their doctor or whether they had a diagnosis. Applicants who are unsuccessful on the exam and would like the same accommodations for a future exam need only check the same accommodations text box on their bar exam application. They do not need to resubmit a TA request or documentation if the request is based on a permanent disability. Applicants with temporary disabilities will need to complete the TA application and submit supporting documentation in their portal each exam. And then, of course, in the cases of denied accommodations, applicants do have the right to request a review of the decision by the Committee of Bar Examiners. Processing times, applicants are encouraged to apply early for testing accommodations as far advanced as possible. I always recommend submitting requests 6 months prior to the exam the person intends to take. Applicants that wait until the deadline to apply will not or may not be able to exhaust all their administrative remedies, such as appealing before the deadlines. I want to just make a note here that we staff in the testing accommodations department have noticed an uptick in students applying for testing accommodations earlier. So I just want to say thank you to everyone here, the law school deans, your personnel, for encouraging the students to apply earlier. We have seen it and we are appreciative. Deadlines for the California bar exam and the first year exam are set forth in the admissions rules. However, I've listed the deadlines for the upcoming July exam here. You will notice that the deadline for requesting testing accommodations was closed now on June 1st. Applicants will have until July 1st to seek review or appeal a decision if it was denied or only partially approved. And all emergency TA requests must be submitted no later than July 18th. Okay, some tips for filling out the testing accommodations application. So apply early. You'll hear me say that multiple times. Applying early will give staff enough time to review the application and then notify the applicant if there's any issues. So they have time to correct their issues before the deadline passes. Of course, follow the instructions. In the last few slides, I've provided links with resources that are available online, including step-by-step instructions on how to submit a complete testing accommodations request. Statement of need. So some accommodations may be preferred by individuals with disabilities, such as a private testing room or food during the exam. However, the need for accommodations is determined by an individual's functional limitations, and the applicant should provide a reasonable explanation as why each testing accommodations that they are requested is needed. Of course, don't forget to attach supporting documents. Applicants that do not qualify for the automatic approval process are required to submit that qualified professional form along with their TA application. And then verify your information and attachments in the application portal and then submit. Don't forget to submit. Again, some applicants will go through the verification process and then they forget to submit the application. So it's really important. Let's see. Some common issues, incomplete or late applications. Many students still wait until the few days before the deadline to request testing accommodations, leaving little or no time to fix the issues with their submissions, which may lead to incomplete requests. Lack of clarity. When the qualified professional doesn't answer the questions in the form or simply just lists the diagnosis, make sure that the qualified professional recommends, if they're recommending a specific accommodation, for example, extra time, that there's a clear explanation of why that specific amount of extra time is requested. Writing double time on the exam because the applicant has ADHD is insufficient to determine the applicant's disability-related functional limitations and how those needs relate to the testing accommodation requested. Again, don't forget to attach the documentation. Applicants will tell us that they've received prior accommodations in law school or MPRE, and then they don't attach the verification forms confirming the accommodations. And finally, applicants also should attach any supplemental documentation that is relevant to their request. I listed just a small sample of some of our more common documents that we see, including IEPs, school plans, comprehensive evaluations, etc. These last two slides are links to additional resources on our website. We understand how stressful it could be waiting for a testing accommodation decision prior to the exam. So staff has really worked hard on making the most relevant and up-to-date information available on our TA website. This includes the submission checklist, detailed instructions for applying for testing accommodations, and answers to our most common frequently asked questions. Answers to other common questions are also available on the website, like what's the format and the environment like? What are different types of testing rooms that are offered for the bar exam? Where can I find a list of the exam site location? We've even posted sample bar exam schedules so applicants know their testing day schedules well in advance. And lastly, the TA bulletin, which gives helpful information and reminders to testing accommodation applicants. That concludes my overview, but I am happy to answer any questions that the group may like. Wow, I look at those hands just go up. I'm going to stop sharing. Okay, I don't know who was first.
I think on my Zoom sheet, it shows me, but I don't know if that's right. I'm just going to say that the reason you got all those hands is because all of us get a million emails a day about this. And thank you for this information. And my question is a simple one. Could I please get these slides? Because these can be converted to materials I can share with students and save us all a lot of trouble.
That is exactly what we intended when we put those slides together. Absolutely. They are now posted on the agenda. Thank you, Teresa. I apologize for getting this PowerPoint up late. It is available there, so I think you all can access it from there unless you need a special email.
Thank you.
Absolutely. I'll just go in order. Carly, you're next on my screen.
Sure. Just a quick question. You mentioned that a common issue is that a student will leave a drafted application in the portal. Do they get any sort of email confirmation that it has been submitted, or is the only place that it's going to tell them in their applicant portal?
Once they submit, they get an automatic email letting them know that it's been submitted and will proceed to staff review for completeness.
Okay. And then I'm assuming they get an email alert if when that status changes.
Absolutely.
Okay, great. Thank you. That was it.
Of course.
Thanks so much for the info.
Absolutely. And Mary, I'll go to you next.
I'm sure I speak for all of us. Thank you, thank you, thank you for getting all these links and putting all this material together. This is going to be great for the applicants. I just had one question. So you were giving an example that, like, let's say someone has ADHD and their doctor says, oh, they should have double time, that would be insufficient. But could you give us just kind of an example of what would be a sufficient amount of detail that would describe what the applicant's needs are in a way that we could describe it like this is what kind of a thing your doctor would need to say, or how to phrase it? Because a lot of times they're doctors. They're not necessarily thinking of it from a testing accommodation standpoint. Thank you.
Yeah, and each file is going to be reviewed on a case-by-case basis. So what one person may write for one applicant may not necessarily be enough information as another applicant, but really focusing in on the functional limitations and how their disability affects test taking, distractibility. I've even seen some people do typing tests to see how quickly that they can process information and get their answers out on paper. But really, it's going to be addressing their functional limitations, and that will be specific to the individual. It's a bit of a generic answer, and I apologize, I can't give you exact. Christopher.
Thanks, Christina. My question was about the deadlines for submitting the application for accommodations, and if it's based on the admissions committee, if there would be any consideration of actually making the deadlines earlier. My students tend to wait. They see June 1, and even though we tell them, early, they rebut with, oh, it's June 1. And then, as we know, it can get them into trouble in terms of getting approved or having a chance to get reviewed. So I guess just a kind of a comment / observation that I wouldn't mind if they were given an earlier deadline. It would give us more leverage to nudge them.
I am right there with you. It is a statutory deadline, so it will take, we've talked about trying to move that statutory deadline up a little bit. I think California has one of the later deadlines for applying for the bar exam. So yes, I think staff is with you. We'd love a little bit earlier of a deadline, but it's a bit more of a process. And Devin.
Yeah, thank you for this presentation. It's really helpful. One of the questions I regularly get is about the proof of accommodations while in school. And the website just says attach proof, but it doesn't actually say what form that proof needs to come in and if it needs to be verified. You referenced a form. There's no form listed on the website. And I usually say, hey, there used to be a form. Try to Google that. But is that what you want us to be telling people, or is there an actual form that they should be submitting?
I feel like you teed me up perfectly for that question. Yes, there used to be a law school form that was a state bar form that we asked applicants to fill out. That no longer exists. All we need is a verification letter. It should be on official school letterhead, and it should be signed by someone in your registrar's office or the dean. And Mary Beth.
Sorry, I wasn't going to ask a question, but then what you just said begged a question to me. So can there not be a form? I mean, I know that at our school, having the person who does the verification just sign the form has been the way we always were doing it. Is there a reason for moving away from a form that everyone knows is the right one to use?
We found that not all applicants would use the form. And when we streamlined our process a few years ago, we just thought, oh, throw out all of our forms. We had about 7 or 8 forms. I think that if the schools are looking for a form, we can put one together, a law school form, and send that out to you all and have you all, those that wish to use it, use that form instead of a letter. That would not be an issue on our end.
Thanks. I do. I mean, I will only speak for my school, but I think that would be helpful. It's just helpful to know that this is, rather than asking as people transfer in and out of positions, feeling like they need to recreate the wheel, or how do we do the verification letter? What does it need to contain? If we just be like, this has everything you need, just use this form. I think that would be helpful.
Wonderful. Sounds like I'll put together a form and put up another external resource out on our website. Any last questions? Okay, well, thank you all for having me and have a wonderful day.
Thanks, Christina.
Natalie?
Yes.
Perhaps before we go to the next item on the agenda, we can go back to the director's report. I wanted to give an up-to-the-minute update. The Supreme Court just issued 2 orders. One, approving the recommendation of the Committee of Bar Examiners that for the February 2025 bar exam, we impute scores for everybody who failed for their performance test. And if the imputed score is higher than the score that they were awarded, then we give them, we count that imputed score into the total score. So we will begin working on that immediately to get the revised scores out. Secondly, they issued an order regarding the recommendation that was submitted to them on May 23rd, extending the existing provisional licensure program. This is the version that requires you to ultimately take a bar exam. So extending it for current participants in the program and also opening it to first-time takers of the February 2025 exam or first-time registrants for the 2025 exam, but who withdrew from the exam. The program opens, I did a very quick read just while Christina was talking, so I may not have all the details down. But the program, those rules are effective September 1. There will be a requirement that new applications from these February 2025 registrants be received by December 31 of 2025, and that the program would extend through December 31 of 2027. I believe I have those dates correct, but obviously we will put some notification out to all of the applicants. We will also make sure to send that communication to all law school deans, so everybody has the updated information. Also included in the order was for those who took what was referred to as the November experiment and did not sit for the February exam. Originally, the order said that originally the court had said that those that adjustment, the 40-point adjustment that had been set by the Committee of Bar Examiners, could apply to either the February 2025 exam or the July 2025 exam, whichever the applicant sits for first. The Committee of Bar Examiners and the Board of Trustees asked to extend that to any exam, to the first exam the student sits for in 2025 or 2026, and the Supreme Court did approve that as well. So that will give flexibility along with the waiver of application fees that the bar had already granted, give flexibility to students who are not ready for, choose not to, for whatever reason, are not interested in sitting for the exam in July, but want to sit for the exam in February or July 26. Give them the opportunity to apply the waiver of the application fees as well as that 40-point scaled score adjustment to the multiple choice section. If they had taken the exam and met that threshold, and everybody who met the threshold had been notified the week of March the 5th, I believe, whether they'd met that threshold. So hot off the presses for you all.
Donna, thank you. We often keep a section of the agenda for recent developments. I don't know that we've ever had a report that is quite so recent, so appreciate you summarizing that because I know there's great interest in it. And I also see a couple of questions. First from Mary.
Thank you, Donna, for the update. And I know it is truly hot off the press.
Yes.
However, the next question, of course, is going to be how long to find out about results for the P2 imputation people, do you think?
So we had run preliminary numbers. So we just need to QC. We need to QC that. So today is Tuesday. I am hopeful that we can get this out end of the week.
Today is Wednesday.
Today's Wednesday. Am I still hopeful we can get it out at the end of the week? I think I'm hopeful we can get this out at the end of the week. But yes, we just need to quality control because I do not want to inform somebody that they are in the pool if they're not, or that they aren't in the pool when they are. So we need to make sure that we do some QC on that. Yes, so our goal is to get that out before end of day Friday.
Thanks. And there's also a question from Carly.
Yeah, and then along those same lines, Mary, I had the exact same question, but so that's when the applicants will be notified. I'm assuming that the law schools aren't going to get the updated pass lists this Friday as originally planned. So do we have any idea when the law schools will get the updated pass list?
I'm going to have to defer to someone else to answer that question.
Thanks.
I would say we'll try to get it out one more week out.
One more week.
Again, those things all have to be checked on our end as well.
Great. Thank you.
What we were originally going to share with you in an item a little bit further down on the agenda was that Friday was planned, but that the timing would be changed if we were to hear from the Supreme Court, which we now just have Okay. Okay, I don't see any other questions. So I'd like to welcome Vicky Avila from our Department of Regulation to talk about the process for issuing bar numbers and beginning law practice. And we are in the process of promoting her to join you.
Hi, everyone. Thank you so much for having me today. My name is Vicky Avila, and I'm one of the program supervisors in the Division of Regulation. And I just have a short PowerPoint to share with you and some reminders for law students or once new admittees once they pass the bar exam. So Teresa, if you don't mind starting the PowerPoint.
One moment, I will share my screen.
While she's getting that set up, just some of the items that I support in the office are status changes for licensees, and other item is overseeing the processing of oath cards and handling new admittee inquiries. So we can go to the next slide, please. So a few things that I'll just go over. How to enroll with the state bar after being admitted, steps for contacting the state bar in the event that they do have questions, and how the fees are impacted based on when new admittees are admitted. Just processing time, so how long it takes from the date that they submit their oath card to when they get their bar number. And then lastly, just some common mistakes to avoid during the enrollment process. We highly encourage the newly admitted licensees to plan ahead, and we do encourage law schools to promote the enrollment guide during maybe counseling sessions before they're on the motion, and to just reinforce for them. There's a lot of information on the enrollment guide, but it's very helpful. So next slide, please. So how to enroll? So the Office of Admissions does notify the new admittee directly by email when they are permitted to take the oath. It will come in a DocuSign format. Within that email, it does contain information and reminders about reading the enrollment guide. Yes, it does have a step-by-step guide, but also the link itself in the document from DocuSign does have the link to the enrollment guide, and I'll share a screenshot with that later. But part of that is, as I mentioned, the attorney registration information section, and then also just the oath itself and ways to submit the oath card. So next page, please. And so this is how to, an update that we included. I apologize, this is really small, but this is our first information page before the oath card is submitted. And so what we wanted to highlight is, one, again, you're going to hear me say the enrollment guide a lot, but two, some frequently asked questions that is within our enrollment guide. But because I think it can be very information heavy, it's a lot to read. So new admittees tend to just click that DocuSign link and just go. So we are highlighting some questions that do often come up, such as how do I complete, how do I submit, and if they'll receive confirmation, which unfortunately we do not provide confirmation just because we're trying to get out these bar numbers as quickly as we can. But we do encourage licensees to constantly check the website for their bar number. And that's it. So those are just the few frequently asked questions that we received that we wanted to highlight on this updated page. We also, at the bottom, we do have questions. So one of the main questions we were getting was, hey, I messed up my DocuSign link. I need a new link. So we wanted to highlight, like, these are the types of inquiries that come to us at the Division of Regulation. And if you need a new link, to please contact admissions directly. Next slide, please. So previously, we used to have instructions to submit oath cards via oathcard@calbar.ca.gov. It has been decommissioned as of December 30th. And so every inquiry should be submitted via our licensee records and compliance inquiry form. And I just provided a screenshot of basically what they should be selecting in order to get to routed to the correct person. So one, just selecting that they are a newly admitted licensees and a bar number is pending. Then the topic of oath card, and then they can choose any of these areas, and that'll be routed to the correct group. We did do a full sweep to make sure that that oath card email is not on there. If by any means, if you do come across something, please let us know, and we'll be sure to update that information. Next slide, please. So how the date a new admittee takes the attorney's oath impacts annual fees assessment. So the first year fees are based on the date of admission. And so here to your right is when you take your oath, how much you will be assessed. So January 1st to May 31st, you are charged the full year fees. This will be updated with 2026 fees closer to the next, towards the end of the year for the next group of new admittees. So right now, we are getting the people that were admitted after June 1st. They are charged only half-year fees. And then December 1st to December 31st, the annual fees for 2025 are waived. And then date of admission, that is the date of when the oath is taken. So new admittees can start practicing as soon as they are admitted. And it's not the date that they sign their document or their oath card. It is the date that is signed by the authorized official. So there was a bit of an increase from 2024 to 2025 full year fees. There was an increase of about $88 and half year fees about $55. There are two classes of licensees, active and inactive, and new licensees are enrolled at the active status and they are billed active fees for the calendar year. Sorry, give me 1 second. While transfers to inactive status can be done at any time, new admittees are not eligible for the inactive billing rate for that calendar year in which they are admitted. So next slide, please. Processing time. So we have this indicated in many places, one throughout the enrollment guide, two also on the attorney registration information section of the oath card. We do mention that there is a 30-day processing time from the date that they submit their oath card, not the date that they have their oath card signed. And another reminder that they should just be checking back on the attorney search page to confirm that they are enrolled and they have their bar number. In the event that we do get inquiries from licensees saying, hey, it's been over 30 days, where's my bar number? We will follow up with them, let them know, and provide their bar number. And so I'll highlight maybe one of the reasons why we get over those 30 days, but in the following screen. Next screen, please. So avoiding these mistakes. Taking the attorney oath before you are eligible. Sometimes, the new admittees, they get excited. They share maybe their oath card with their friend, but they are not yet on the motion. That will prevent the bar number being assigned. We will hold on to that oath card and reach out to the licensee, letting them know, hey, you're not on the motion yet. And then we'll work closely with admissions to see what the holdup is. Signing your form before you have completed all changes in DocuSign. Some folks will just sign it. They haven't scheduled a swearing-in ceremony, and so they'll just submit it thinking that's it. But we will again come back to them and let them know, sorry, you haven't had it signed yet, so please go ahead and schedule a time to be sworn in. Submitting your form with a name that does not match the name shown on the notice of results. It happens not that often, but there is an option on the oath card that does say, like, if you are also changing your name, to please submit a name change request form. And there is a link to that on the oath card itself. Number 4, or the fourth one, is not providing a mailing address and or phone number. Addresses are mandatory. Phone numbers are also mandatory. One thing I did not include on here, email addresses, a public email address is optional. However, highly, highly, highly encouraged. When we process the oath card, bar numbers assigned, we do submit or provide letters of the access code so that they can access their My State Bar profile. We send that to their address of record, but for those who do provide us with a public email, you will also get an email reminder. So highly encouraged, not mandatory for email, but highly, highly, highly encouraged. And the 5th is submitting your oath card without the required signatures and dates. One of the common mistakes that we see, besides a signature missing, is also even there's a section for additional jurisdictions. We do ask that the new admittees include where they are admitted, month, year, and where. Sometimes they'll just put New York, that's it. So we will reach out to them just saying, please provide the month and the year. Next screen, please. Oh, and that's it. And I appreciate your time. And if you guys have any questions, I am happy to answer.
While they're thinking about questions, one thing that I might add is circling back to the beginning. When they're waiting for their oath cards, we send a motion to the Supreme Court. Ultimately, the court signs the motion, returns it to the State Bar, and then it's processed so that all of the oath cards can be sent out through DocuSign. So there is a period of time between the moment that the court signs and the time that the oath cards are issued. We do process them in batch. It's not possible to expedite any one specific admission at that point. And sometimes applicants will call the court and they'll contact us and they'll say, hey, I know that the court has signed this and it is in that processing period. They don't need to call the court. We know this is something that's highly on the minds of all of the individuals that wish to newly enroll, and they are sent out by admissions as soon as possible. So their cue that it is ready is that they do receive the DocuSign, and they can see in their Ames portal, the applicant portal, the motion that they are on.
And I just also want to remind, admittees, when it is also in the enrollment guide, everything is processed on a first come, first served basis. This does even include law schools who may be having a swearing in ceremony. We like to still process them first come, first serve, and we can't give higher priority over others, and just really appreciate everyone's patience. But Devin, I see you have a question.
Yeah, when you all moved to the electronic cards, it definitely took some adjustment because we are one of those schools that does it electronically. It took us a while to help the judges understand how to make it work. I'm surprised to hear that the email address is out of service because we send all of our oath cards there last month. And so I hope that there is someone actually looking at that, because I'm sure that we're not the only ones who did that. And there was no bounce message that we received, but it didn't work. With assuming that the new process is like, hey, upload them through this form, are you suggesting that each one has to be uploaded individually to be processed now?
If you were to ask me, it is helpful if people upload them individually, and that's only just because if there's an issue with their oath card, we can reach out to them directly. We do have some law schools that do upload the entire batch, and which is fine. Just in the event that there is an issue, and if the new admittee does not provide an email, then we have to go back to the law school person who submitted the batch, and then they have to go reach out to the new admittee. So that's why emails are highly, highly encouraged. But either way works.
Yeah, I know that that's what we will be doing, because like doing 70 individual cards is not a meaningful thing for my admin to do. But what about that old email? Is that old email address just not receiving any messages, or what's the story with it?
It is no longer receiving emails at all. So you should be receiving, for a while, it was actually decommissioned before December, but we were checking emails just to make sure. But it is completely closed, and you should have at least gotten like one of those like really hard bounces within a few hours, at the most like a day.
Okay, I'll let the dean's office know, because they sent all of our oath cards there and they've been wondering why they haven't been processed. So now I know why that happened.
Okay. there's no more questions, thank you so much for having me, and hope you guys have the great rest of your day.
Thanks, Vicky.
Bye-bye.
Okay, so next we want to talk about something that is not new, but when we talked about this at CS Bars, it was new information for some, which is a report on the availability of some MCLE credit for moot court participation. And I'll ask Teresa for the slides. Thank you. So there is a rule that is relatively recently passed within the last couple of years, 2.84, offering MCLE credit for mock trial, moot court, and other similar competitions. Many other states have had a rule like this for a long time. Historically, California did not, but now attorneys can claim up to 2 hours of participatory MCLE credit if they're attorney coaches, scorers, presiding judges for mock trials, moot court, etc. Several specific items that you can see there in sub A. And notice that this applies whether the attorney is participating at the middle school, high school, college, graduate school, or law school level. The MCLE credit hours are not available for grading written briefs or written papers in connection with the MCLE activity, but there is a lot of live competition type of support, like you see set forth in sub A. There is not the ability to claim additional hours for prep time. Coaches, I know that you spend a lot of time with the prep. Unfortunately, that does not qualify. And this is general MCLE credit, not the special credit. So we wanted to make sure that everyone is aware of this so that if you have these types of programs at your law school, or you are supporting these types of programs in the pipeline leading up to law school, that you can make this benefit available to hopefully encourage more attorneys to be a part of it. Let's go next slide. There's just a little bit more detail here about this, and we hope that people will take advantage of it. Many of your full-time professors are getting their MCLE credit just from their teaching as well as doing their special subjects. But for your adjuncts and for your attorneys that come in from the community, we hope they'll be able to take advantage of this benefit. So let's take down the slides and see if there are any questions, or if anyone has claimed this credit to date. Has anyone here in our audience, or have you offered this yet to your attorneys? Okay, well, I hope you will consider doing so in the future. It is something that they can look up on the website and double check and verify. And we hope that it helps to continue to enrich the types of programs that you do for moot court and mock trial. Okay. So another thing we hope that members of the public who are watching will do is help to enrich participation by participating on the Law School Council. So I'm going to turn it over to Teresa Zelensky to talk a little bit more about how to do that.
Hi, everyone. Give me 1 second to put these slides in presentation mode. This is going to be pretty brief, and I appreciate the chair kind of teeing this up in the chair's report. That was a great recommendation for us. So we are in the process of accepting applications for the Law School Council. So right now we have we will be having 2 openings coming up, so we'll have 2 vacancies. Administrators at ABA approved law schools are eligible to apply. Right now, the deadline is, the application is up on the Law School Council webpage, and the deadline is posted there as well. It's June 30th. So it is coming up, but it's a pretty short application. So hopefully, it won't take you too long to apply if you would like to. In terms of the timeline, once we have all of those applications submitted by the June 30th deadline, there will be processing time, and we will share those applications with the Committee of Bar Examiners Chair and Vice Chair, so they review those applications, and then candidates will be selected and notified in September of 2025, and that's when the term will start. Terms are usually 4 years long, and I think that's all I have. If you have any questions about the application process, you can always email us at lawschoolregulation.calbar.ca.gov, and we'd be happy to answer your questions or point you in the right direction. The chair also mentioned something about, you know, how much he enjoyed being the chair. And so for those of you who are on the council right now, I will remind you that we are still accepting applications for that as well. And that is a one-year term. I think that's it. Is there any questions on the process? All right.
Okay,
Well-
why don't you continue on with the report related to the distribution of pass lists, which we've seen change right before our eyes, but there's still some helpful information to share here.
Yes, absolutely. So let me get that teed up. Unfortunately, I think all of the the juiciest details you already have asked us, rightly so. Those are the important details, but there are other things that I just want to go over about the process in general, perhaps not about this bar exam, but the process in general. So I think this will be helpful. So as a reminder, and we did discuss this briefly, the pass-fail lists are distributed via email to the law school dean's email that we have on record. So this is just this is to say, please, please, please make sure that you update us if your dean has changed or your dean's email has changed or both has changed. That's really important. And I also wanted to just, and you can send those changes to lawschoolregulation@calbar.ca.gov. And I also wanted to just note that sometimes we do get requests for lists, people who say that they haven't received them. And sometimes it's the registrar who emails us that. And I just wanted to flag that we only send these lists to the law school dean, who could then distribute the list internally. But from our side, we only send them to the dean's email. So if your registrar emails me and says, hey, can I have the list? I won't be able to email the registrar back, but I will, of course, email the dean that we have on record. And so you should generally try to keep a lookout for those on the Wednesday following results released. I know that this time around, the process was a little different, but generally speaking, the Wednesday following results released. And then we already touched upon the revised list for the 2025 exam. I know you received lists a few weeks ago, obviously because of the change in results. And now we're going to be doing more imputations. Please just stay tuned. It sounds like we might try to get something out to you by the end of next week. You will only receive a list if you have an update. So if your school's list was not affected, there is no change in the outcomes for any students on that list, then you wouldn't be receiving a list. And just as a general reminder, please hold tight onto those lists. I know that there are changes in deanship and things like that. So make sure that even as positions change, it's really helpful to make sure that you have those lists, historical lists, somewhere handy, so you can just grab them easily and just, be aware that they should be always coming out shortly after bar exam release and to the dean's email.
So I think part of what's being referenced there is that when your school is calculating the ultimate pass list, the school is responsible for maintaining the lists, and we do not retain them internally. So when you call near the deadline to request those lists, if you ask for the multiple years historical, we recreate them for you. So we would ask you to please hold on to them. Okay. Thanks, Teresa. Were there any questions about the pass lists? Okay, let's move to another report that is still helpful, but yet also outdated based on earlier events from today. So this one is for me. It does not contain slides, but I wanted to talk a little bit about the November California bar exam scoring adjustment. So I was going to say there's not new news here other than what we just heard right now, but in terms of how that adjustment was handled, for those applicants who were a part of the bar exam experiment back in November of 2024. If they took the February 2025 exam and passed the exam, consistent with practice, their scores are not released. So those who passed the February 2025 exam were not advised whether or not a scoring adjustment was part of that pass result. They were simply given the pass result. And for those that did not pass the February 2025 bar exam, the first email was a part of release of results, and it included their multiple choice scaled score, both unadjusted, and then also with the score adjustment if it was applicable to that person. They received a subsequent email informing them of the number of questions that they had answered correctly during the November 2024 experiment session, whether or not they had met the minimum threshold to be eligible for a score adjustment, and whether the adjustment was ultimately applied. Those who were part of the November experiment but did not sit for the February 2025 exam were sent an email stating whether or not they met the minimum threshold, and they would be eligible to apply the adjustment to a future exam. At the time they received that, they would have had reason to believe their opportunity to do so would have been limited to this summer July 2025 exam. We've just heard via Donna's summary that it could also be whichever is the first exam that they take as of July, or the February and July exams in 2026. So just wanted to make sure that you were clear on the communications that your graduates were receiving if they had participated in that fall 2024 bar exam experiment. And we thank everyone who did participate. Okay. So that's what we have. And I don't see any questions, so let's move to welcome Ken Norse from our Lawyer Assistance Program. And he and I will be talking about some of the State Bar complementary bar prep programs, and this is complementary with an E as well as an I, because they are in fact free, and they also complement the standard bar prep that you're offering through your school, or the commercial bar prep package that the graduates may be taking. So we've talked about these programs a little bit before. These programs have benefited from your feedback, and we encourage you to continue to provide that feedback. And we want to talk a little bit about what they look like today and how the different programs can fit together to complement, with an E, your graduates' bar exam prep. So welcome, Ken. And I will go ahead and begin as soon as we bring up the slides.
Give me one moment, and I'll get those up for us.
Excellent, thank you. Okay, great. Let's go on to the second slide. So the State Bar offers a number of free programs to complement bar exam prep. The Bar Strategies and Stories program, which is offered through partnership with the Indiana University Equity Accelerator. That's something for the start of bar preparation. New this year, the Peak Performance Program, offered in conjunction with Stanford University Mind and Body Lab, the Wu-Tsai Human Performance Alliance. Some people have asked if it's Stanford Law School, but it's not. It's the Mind Body Lab. That's a program that extends mindset performance throughout the entire study period. Reset, the bar exam Retaker support program, and we're very glad to have Ken Norse here, the coordinator of that program, as well as Mary Basic, who is a professor participating in that program. And then we continue to offer other programs that are not specifically bar exam related. They are available to all students and all graduates and all applicants at any time. The Refocus ADHD Support Group, which is something that is offered several times a year. Ken might be able to tell us a little bit about when it will be next offered. I think most likely in the fall. and the Imposter Syndrome Toolkit, which is available on the State Bar's website under the LAP section, but also under the admissions website as well. Next slide. So what we would like here is we'd like to talk to you about a way that these programs can fit together to assist applicants in their bar preparation. We understand that this is a stressful time, this is a challenging time, that students are thinking a lot about time management. And if you can create a frame for them, showing them how all of these pieces can complement what they're doing, I think it can really help them to best take advantage of these free programs that are available. Ideally, in a steady schedule, in addition to their normal bar prep, which they're taking from your school and also from any commercial provider, they should begin the Bar Strategies and Stories program as soon as they can in the process. Ideally, that would be the first thing they do before they begin, because it's about creating a productive mindset that will help them to continue to be ready to absorb the material and be resilient in the face of obstacles that they may meet. This is the one program so far where we've presented some public results, and they've been consistently strong over a number of different bar exams. And it takes less than 2 hours to fully complete the program. A great idea that we've seen is having people actually weave this into the bar prep program and just say, hey, for this class, this 90-minute or 2-hour session, we're going to have you complete Bar Strategies and Stories as a part of that. Next, their commercial bar prep will begin. Once it begins at the same time, so does the peak performance program. That will be 6 hours over the 10-week study period. And then shortly thereafter, the Reset Bar Exam Retaker Support Program will start. For those that want to take that, it's 5 live sessions. They are Monday evenings, starting at 6:30 p.m. And this particular session started this week, June 9th. And then this continues along with our bar prep program through to the California bar exam. Next slide. So we'd like to ask for your help in getting the word out about these programs, but also hearing from you about how we can communicate about these. In particular, alumni may not know that these programs exist, and they may not have been available when they first graduated. So getting the word out to them is really helpful. They may not know to look because they weren't expecting these new programs. And having an endorsement from you can really make a difference. If you introduce this toolkit early in the process to them, that also helps. So as early as you can, whenever you start your thoughts about preparing for the bar exam, any type of announcements you make, please think about including this toolkit and noting that it's available at no charge. Also, we'd really appreciate it if you can include programs and their timing milestones in any type of law school bar prep that you do. I gave the example a little bit earlier about setting aside one of your bar prep sessions to allow the individuals to complete Bar Strategies and Stories if you do a post-graduation type of session. So the Bar Strategies and Stories program doesn't become available until they begin their study in June, but we know that quite a few schools continue to support their graduates after graduation and before at least the first bar exam. We also wonder if you would consider offering an incentive for evidence of timely completion. When we were working with the registered and accredited, accredited law schools, some of them did a raffle actually for those that were presenting the evidence that they were registered, and they could win prizes. So I don't know if that is the way to go here, but that's something we've seen. So I wanted to open it up to the group before we take a deep dive into the program that CAN coordinates and that Mary is a part of. How are you doing this right now? Or do you have some thoughts about what we can do or what you can do to increase participation, which is already high in these programs, so that all applicants can take advantage of them? I see a question from Susan.
Natalie knows I'm a huge fan of strategies and stories, and I tell all my students to do it. Are we still in the phase where this is a research project and students can only sign up and get their individual link by clicking the box when they register for the exam? Is that still the only way to access this program? Because that has been one of my difficulties, is particularly in the last few bar exams, students have been rather panic stricken when registering. Locations have changed, and people are trying to do it at midnight. It's the middle of the night. They're rushing, and they tell me the next day, I never saw a box to check for this. I know that sometimes there used to be a second chance email, but that would be my problem with setting aside time to do it, is what do I do with the 10, 20 people who show up and can't access it?
Ah, I see. Okay, it is still a part of that study. So one opportunity is when they're registering for the exam. And then again, they do have 3 reminder opportunities to sign up via the email. They do have a unique link, so it must be their own link. They can't share it with others, but they will have it in their email. I understand that you might need to nudge your students to open their email box, but when they do, they hopefully will be delighted to find that invitation. And when the program is sent out, we also send it out in 2 waves. So ideally, you want to do it as early as possible. But for those individuals that didn't sign up in one of the earlier reminders or when they applied, they can be a part of the second wave as well. So we've looped a couple of safeguards there to try to bring those folks in. And also what would help us is part of the way that we can do this and offer it at this no charge situation is because we are doing this. So the unique links, they go hand in hand. So if they can be prepared to say, hey, when you're seeing the application, here's what this looks like, watch out for this, then that might help. I don't know. I could look to see if there's some sort of screenshot we can show you of a page so that it's something you could have in your materials. Do you think that would be helpful?
Yes, I think it would be helpful. A couple students did screenshot it for me and send it to me off a couple of applications, but those are kind of random. It would appreciate seeing a clean one that doesn't have any identifier information on it so that I could use that screenshot to show students. I just want to make sure I heard that right. There's 3 reminders for the first round.
There
If you miss it,
there should be. I
Yeah,
can double
there
check.
are.
okay.
We understand that email is it will remain in there, and for some it might remain unopened. So
if they go back and pull up an old email, that link should still work and be unique for them.
yes, so their invitation should contain the same unique link from the time that they start the application process and then through those 3 reminders as well.
Thank you.
Yeah, great. Thank you. Okay, so let's turn it over to Ken to talk a little bit about the Retaker support program.
Thank you so much, Natalie. And if you could pull up the presentation again, I do have some slides that I'll speak to. So this is actually the 3rd iteration of our Reset Bar Retaker support program. And I'm really happy to say that we have just blown the barn doors off eligibility requirements. In the past, as it was just really a pilot program, we limited the participation to graduates of California law schools who were taking the general bar exam. And so that meant that people in past sessions who graduated from law schools outside of California couldn't participate. And also that people who were taking, let's say, the attorney exam were not able to participate. But this time, we've actually taken off all of those restrictions so that more people can access the program. If I could have the next slide, please. So this program has changed format sort of in response to changing conditions over the last 2 cycles. For this particular cycle, we have 5 sessions. As Natalie mentioned, they begin, they're on Mondays starting at 6:30 p.m. We wanted to make sure that people who were working and who had other obligations would be able to attend the live session. Due to the difficulties with the February bar, for this particular reset program, we have started the very first session focusing solely on mental skills with our resilience reset. After that, we have essays, performance test, and then multi-state bar exam. And then we finish the 5th session with endgame study strategies and self-care for the final push. This program is really supposed to be complementary to the strategies and stories program, which is asynchronous and doesn't really have any live interaction. Although our reset program is live and there is interactivity with participants, I'm very happy to say that we also release recordings and materials from each session within 48 hours of the program. So our first session for Resilience Reset, if I could have the next slide, please, which was led by Laura Lisby, who's a State Bar of California Lap Group support leader, and she's also a private practitioner. We had really good turnout, and I'm happy to say that we had a 95% satisfaction rate for our Resilience Reset. The idea is to get people who are retaking the bar in the right frame of mind for the rest of their study period, as well as for our subsequent sessions. On next Monday, on June 16th, from 6:30 to 8:30, we'll have our essays session, which will be led by Lindsay Harrington, who's Director of Bar Support and Assistant Professor of Law of Legal Practice at McGeorge School of Law. We'll follow that with our third topic performance test, which will be led by Dean Basic from UC Irvine. Thank you very much, Dean Basic. Following that, we will complete the substantive sessions really with our multi-state bar exam, our NBE session on June 30th, and that's going to be led by Tina Schindler, who's an associate professor of law at Western State College of Law. And then we bring everything together, combining both mental skills and study skills in our endgame strategies and self-care for the final push. That'll be held after the July 4th holiday on July 7th, again in the evening from 6:30 to 8 p.m. And that'll be led by a combination of Dean Basic and also Laura Lisby from the State Bar of California LAP program. So as I said, we just had our June 9th session, but to let you know, there were actually individual invitations that were sent to every retaker to register. There were actually four different waves of invitations that went out. But if you have a straggler who has not yet signed up that you learn about, I do encourage you to have them to register for the program. They will have access to all of the recordings and materials from each of these sessions. We actually have 2 bonus recordings on top of that that are being released to participants. The first one is actually Dean Basic's score report and customized bar study plan from the February 2025 bar. We just recycled that for this particular session. And because we've allowed students who are coming to us from law schools outside of California, probably in the middle of this cycle, I will also be releasing a California distinctions section that was recorded fairly recently by Jonathan Chu from UC Irvine School of Law. So this is the program as it stands for this particular cycle. We'll sort of take feedback and other indicators to determine how we might massage it for our February 2026 Retaker program, which we're already in the process of planning. Beyond this, I'd like to talk, next slide, please, about the imposter syndrome toolkit that we have at the State Bar that Natalie mentioned. Imposter syndrome is a common challenge among high achievers. All of us have come across students who've encountered this, and maybe we've encountered it ourselves. It's really marked by self-doubt and difficulty in accepting your own great accomplishments. The goal of the toolkit is to help people through limiting thoughts by creating a new framework of thought and mindset. There are things like an imposter syndrome worksheet, which I've included a link to and which is in your copy of this presentation. And that worksheet was actually adapted from great resources that the Oregon Women's Lawyers, OWLS, developed, and I've also linked to that as well. There are resources that are available for really everyone through the toolkit. We have just general information about imposter syndrome, resources for attorneys, employers, and really relevant to this group, resources for law students as well. So that completes my overview of lab programming related to bar prep. If there are any questions, more than happy to entertain them.
I see a question from Susan.
Thank you. I just wondered, I realized that Mary's recording about score review would be very distinctly interesting only to someone retaking the exam, but the second recording you mentioned on California distinctions, I feel like would be relevant for first-time takers. Is it possible for us to access that recording somewhere?
That's a great question. Really, we really haven't looked into making all of this programming widely available outside of retakers. That's definitely something that we can look to internally. It's a new resource for us as well, as I said, just because we've decided this cycle to invite all retakers to the program. But I really appreciate, the suggestion, and I'll certainly turn internally and coordinate with Natalie on that. Thank you.
And then Ken, I'll raise my own hand. I just want to
Sure.
confirm if a student has said, if a graduate has said, hey, you know what, I really didn't notice this. I was busy, I was distracted. I've cleaned out my email box. I have none of those historical items. How can they register at this point?
Yeah, I would encourage anyone who's interested in registering to reach out to us at lap@calbar.ca.gov. That's the General Lawyer Assistance Program email. Again, lap@calbar.ca.gov. What will happen is the email would be forwarded to me by the staff member who views that inbox, and then I'm able to manually register people. So more than happy to do that. My goal is to get attendance as high as possible.
Okay, great. I'm glad to hear that. Thank you.
And then, Natalie, you also mentioned the ADHD refocus program that I run. We just had a cycle run in March this year, but you are absolutely right, just for everyone's information, that another refocus ADHD support program will be running in September. And that program will have 3 live sessions that'll focus on the most common areas of executive functioning difficulty among attorneys, and that is motivation regulation, working memory, and problem and planning solving. And then in our pre-recorded library, we'll be targeting the other 3 areas of executive functioning. We won't do that on the live just because they're really not as commonly encountered according to surveys that we've taken among program participants. And those are things like emotion regulation, self-awareness, and a third topic as well. But that information, if any of you want to let your students know about that, there is a LAP program offering a mailing list that they can sign up for, and they are able to get notified of that if they're interested in it. Alternatively, I encourage all of you to sign up for that as well. Push another area of programming that I'm really big on, and that is our mindfulness programming. For the last 2 years, I've run a spring mindfulness series, which I'm considering calling Revive, to help us better focus, mindfulness, coming into the moment. It's a great opportunity for law students, bar applicants, and practicing attorneys to develop mindfulness practices. So I'm expecting that programming will be reiterated again in April, but again, the next cycle for ADHD programming is in September.
Okay, so then just to recap, the program, which may be called Revive, the mindfulness program, that's available to everyone, including the attorneys in this meeting that are at law school. So administrators can attend as well.
They can. I actually partner with the Mindfulness and Law Society on that. It's an incredible organization that was developed, I believe, in 2018, really following up on the 2016 Pathways to Attorney Wellness report that the ABA COLAP committee issued. It's actually a national chapter, and I'm really a national organization, although I sort of participate in Mills in my official capacity with CalBar LAP. I'm really happy to say that we just had a new member join out of San Diego, and he will be forming a Southern California chapter of Mills. And I'm hoping to put on more California-focused mindfulness programming, hopefully in collaboration with a Southern California new Mills chapter.
Thanks, Ken. Are there any other questions or comments for Ken? Mary?
Just something for Ken to put on your to-do list, but going off of, I think it was Susan's comment, gosh, my memory is not what it used to be. I'm pretty sure it was Susan a second ago, about that the California rules would be good for all students, the first timers and everything. Honestly, so would the other workshops. Like all of the workshops would be, it's really, of course, it's an overview, you're doing it quickly, but they would be really helpful. And so something that might be worth looking into is making maybe a recorded version instead of a live version available to applicants. I think it would be super helpful for particularly for people of limited means, it would at least get them started in the right direction with good advice. And so if throw it on your to-do list, Ken. Okay.
Thank you, Mary. I really appreciate it. And you sort of forsaged a plan that we have to work on possibly packaging everything together so we can push it out to law schools. I have a meeting with 2 academic success professors in August to begin working on that toolkit. So thank you so much for that advice. And with the toolkit, all of you could do whatever you'd like with that content. So if you wanted to repurpose it, even for your first-time bar takers, more than happy. As you know, Mary, and everyone on this call, my focus was really on the retakers, but I would love for all of this material to be as distributed as widely as possible.
I want to thank you both for making these programs happen and helping to make the public aware of them. So thank you, Ken. And thank you, Mary. Okay, so I just wanted to let everyone know, I wanted to convey apologies from our chief, Jana Hershkowitz. She has had to step away from another meeting, so that's part of the reason why she wanted to give you the Supreme Court update before she did step away. And she appreciated the opportunity to spend time with you today. And then before we move on to our discussion item related to past and future bar exams, I just wanted to circle back to confirm the passage of the minutes. Do we need to?
Yes, that's next. We haven't done that one.
Excellent. Okay, we zipped right to a special set item. So before we turn to the discussion, let's review potential adoption of the minutes.
Yeah, thank you, Natalie. So we are talking about approving the February Law School Council open session minutes. And at this point, I'd like to ask if anybody has any changes or updates to those minutes from the February meeting. All right, seeing no changes or updates, I'd like to call for a motion to approve and then a second.
I'll move to approve.
Second.
Thank you. Teresa, would you please take a roll call vote?
Susan Bakshian,
Approve.
Mary Basic,
Approve.
Tiffany Gabrielson is not present, Devin Kenyon,
Approved.
Mary Beth Moylan,
Abstain.
Carly Sassy,
Approve.
and Chair Christopher E. Didon.
Approve. Thanks.
All right, so with 5 yeses and 0 nos, the motion carries.
Thank you.
Excuse me, Mr. Chair, I have to step away for a second, so I just wanted to let you know I'm turning my camera off. I'll be right back.
Thanks, Devin.
Okay, so I think we're ready to turn over to our discussion item, update and discussion regarding February 2025 bar exam, plans for July 2025 bar exam, and pending discussions about the future of the bar exam in California. I'm welcoming Audrey Ching to lead that discussion.
Thank you. And some of it we've pre-discussed. Now that there's some hot off the presses thing we've shared. So this is the item title that Natalie just read for me. Thank you. And just gonna do some recap quickly, although I think everyone is caught up. The February 2025 bar exam, there was a lot of technical and procedural failures, and I think we all have that level set now. Supreme Court approved initially these scoring remedies recommended by the Committee of Bar Examiners, lowering the raw passing score to 534, which was 2 standard errors of measurement beyond what the psychometrician recommended, and then scoring imputation for incomplete answers. So that already happened. And then the order today that we just already had a hot off the presses recap is to expand the provisional licensure program. So extend it. So there's still 2020 graduates remaining in the current pool. So extending their end date that was supposed to sunset at the end of this year, extending it to include them in this extension, that it's now going to be open to first-time takers and first-time registrants, so those who withdrew from the February exam. Admission on motion was denied without prejudice for out-of-state attorneys, and then an interim special admission program that was also denied without prejudice today. Sorry, on May 30th, there were additional scoring remedies recommended by the Committee of Bar Examiners to use the higher of the 2 read scores for each essay and performance test. And then today, the imputation. So imputing the performance test for all unsuccessful takers. And to the extent the imputed score is higher than the given score, the imputed score will be used. So that was just approved during this meeting. And then the court order today also extended the November special study adjustment, which Natalie was discussing earlier, through the July 2026 exam. You can only use it one time, but it can be used for this coming July exam through July 2026. So on Friday, we notified 230 additional examinees that they moved from fail to pass after doing that. Instead of taking the average of your first and second read, taking the higher of the 2 reads. And then this order back today to impute the performance test for all unsuccessful takers, that the preliminary number that we gave to the court for its consideration for the order was about 79 applicants. We need to, like Donna was talking about, go through and do the psychometrics and make sure that we have the right list QC'd. Hopefully that out by the end of this week. July 2025. By June 2nd, when the exam application closed, we had 9,796 applications. 4,391 of those are approved. 4,842 are still pending. Those 2 numbers don't add up to 9,796 because we've had withdrawals as well. So just because of the audience, the certifications to law schools were delayed. We've started sending out this morning the certifications. So that pending list will start getting smaller and smaller as we send the certifications out to the law schools and get back who is eligible for the July exam. We've had almost 1,300 testing accommodation applications. The deadline was June 2nd. We will receive emergency applications for emergency accommodations up through 10 days before the exam. So that number will increase when we have more emergency applications as well. Just so you know about our proctor numbers, we are targeting for all the sites, we need 1,350 proctors. We have over 1,000 already onboarded and going through the rest of the pipeline to get everything ready for July. Just a reminder that February 2025 applicants have a waiver they can use for this exam through the July 2026 exam. These are all the test center sites. I imagine you're pretty familiar with these. The State Bar office is being used again. That's about 160 accommodated applicants we can fit there. We're also using Golden Gate University again, if you're familiar with that law school and undergraduate space. A lot of these we have used in the past. One of our newer sites in Chula Vista, we are returning there as well. July is a different temperature across most of California. So we will be putting out in all of our different, emails that we start sending out to applicants before the exam every Friday, making sure everyone knows about dressing in layers and preparing for where they might take their lunch breaks. We'll have some shady areas and some of the warmer spots in California. Looking ahead, okay, so hopefully this shows up. Okay, this looks all right. So this is the guiding principles that the Board of Trustees adopted at their meeting on May 23rd. And I put them all up here. I know it's a lot of text, but I think it's important in case you didn't go to that meeting or haven't listened to the recording. I wanted to share all these guiding principles with you. Doing it right. This is about the future of the bar exam. So looking ahead to bar exams past July 2025. Doing it right is more important than doing it fast or doing it cheap. Delivering a reliable and predictable exam is a guiding principle. Minimizing risk. If changes are made, phase the rollout, move with caution. If changes are made, use proven technology with appropriate testing and risk minimization. It's a guiding principle to deliver an exam that appropriately assesses for minimum competence. The exam must be accessible, affordable, fair, and equitable. Lessons from this past February exam must be learned before moving to a remote exam. Guiding principle to develop an exam that can be delivered on a more frequent basis than 2 times a year. Caution cannot trump innovation. Consider both remote and in person. Improve work with stakeholders, so more transparency, fold in stakeholder perspectives, seek them out, consider them. Partner with law schools to test exam administration platforms, approaches. Strong collaboration between the Board of Trustees, the CBE, the Supreme Court, and legislative partners. And then we can't rely on business as usual to drive the approach. So that was from the May 23rd. Those were the guiding principles. And the resolution was for that the Board of Trustees recommended that the CBE join them in adopting these guiding principles and delivering recommendations for development and administration of the California Bar Exam for 2026 and beyond. And then this is agendized next Friday, June 20th, for discussion and action to talk about California Bar Examinations after July 2025, including consideration of recommendations related to the Supreme Court order that we've had since last October to develop a California-specific bar exam. Those were all my official slides to share with you. I know a lot of this is recap, so I just will stop sharing now and welcome your questions and discussion. Devin?
I've liked lots of feedback and lots of questions, but I wanted to sort of start by saying, like, I've appreciated the, I'm going to say the grace that you all have handled all of the meetings over the last few months. I know that it has probably not been very easy to do the job that you all are doing. So, you know, we definitely, I'll say me, I definitely have sort of stated some qualms I've had with things there, but I've like never felt like you guys didn't care what we thought. So I really appreciate that. The concern that I have in the future focus part is there seems to be an intent to get back to using the Kaplan materials as soon as possible. Like, I got the PRE website that was like, hey, we're still under contract with them. I have deep suspicion about the quality of those questions. I have suggested in public comments, and I will suggest to you all that those questions that were used need to be released. If we are to believe that they're actually good questions, you all need to prove it. And until that happens, I suspect others on this meeting will be sort of standing with pitchforks out in front of your building telling you to quit using those questions. The suggestion when my students told me, oh, we think some of those questions were written by AI, I was like, oh, there's no way that happened. And then when that came out, I was like, oh, the credibility of those questions is gone. And so I really urge you all to, you know, put them out there and demonstrate that they work before we try to use them again.
Thank you. Susan?
Like Devin, I want to share my support for the State Bar staff that I know is working hard and trying to resolve the issues that have happened in February and get on a better path going forward. And I do think that meetings like this are helpful so that we can work together instead of against each other. And I do think that's the way forward. My biggest concerns are more generic. They're not as specific about, I have less concern about who drafts the multiple choice questions. I have a lot more concern about where is the February exam being given and in what format. Is it being given in person or remotely? Like, big picture, students need to plan. And I realize that theoretically they can all make a hotel reservation in January. But I also realize that it creates an unnecessary level of anxiety to have these issues about that. And I do realize that a great deal of this responsibility falls to the CBE and not to the State Bar staff, and that the Supreme Court has been frankly slow and unresponsive when the State Bar has sent orders in. So I do realize that there are lots of moving parts, but I wonder if we couldn't get a quick announcement, if at all possible, about just the general format and locations for February.
I'm glad you said that because it reminds me of some other things that are agendized next Friday. So the chair of the Committee of Bar Examiners is forming 2 new committees, subcommittees of the CBE, one on exam administration which would be looking at answering that question about what way will the exam be administered in February 26th, and then another on exam development, kind of speaking to the question development. So there was also the Supreme Court edits to rules of court around the CBE's authority that needs to go out to public comment. But those red lines, you can read through what the suggestions are in terms of different things that the Supreme Court wants the CBE to approve, and things about budget related to it's an interesting read about some of the court's edits on the rules of court related to the CBE, and that's going to be discussed on June 20th as well. Some recommendations perhaps from the committee before it goes out to public. I mean, it's actually already posted for public comment. So it's posted on our website for public comment, and the CBE is discussing it. So you can look at those red lines, but we're not able to, right at this point, say to you, oh, well, the February exam is going to be this way, because we actually need the Committee of Bar Examiners to discuss and decide. Mary.
I would like to echo Susan and Devin. I know that this has to have been difficult for all of you, and I really appreciate the communication that we are getting, and I know you're all working really hard. I did kind of just want to capture a concern that I have, that I think is a little bit the nut of why so many things kind of conspired to go wrong. And the State Bar embraced using psychometricians and their expertise, which is necessary to determine if a test is valid and all of that. But the piece that I think was missing, and I would actually be interested to hear from my colleagues on this call, is subject matter experts in the content tested on the bar exam, not just that like in general, but like specifically what gets tested, because of course you can test a particular rule in California or the common law or the majority rule or a minority rule. There's a lot of variation. So specifically what gets bar tested, and the best methodology for using multiple choice testing, because I know you have your edge experts and they have understanding of how the subject matter is tested for an essay, not for a multiple choice question. And it might surprise you to know they test differently. And so I think that a lot of the problems that I was seeing could have been easily resolved if people like many of us on this call had been asked. Like we knew where that was going to go and how it was going to go wrong, but there just wasn't really a forum to use our expertise, which I know I can speak for myself. I will freely give. I really just wanted it to be a good exam for the students and the examinees, which I know you all wanted that too. So I'm not really sure where the disconnect was, that it seemed that the psychometrician took that primary role of that they would know the answer to everything, but they just simply didn't know the content. So if the content isn't right, here we are. So I am probably closer to Devin than Susan about the quality of the multiple choice questions. As far as I don't really care who makes them, but they've got to be good, right? They have to be predictable for the people planning and practicing for the exam. That's all. They can be hard, but they should be predictable and behave the way we expect them to and the way they prepare. So I just wanted to point out that I do think whatever y'all are doing going forward, I do think it's really important to get that perspective of people who actually have intimate knowledge of the exam in all of its components. It will make for a much better experience for everybody. So just wanted to say that.
Thank you. I appreciate that. I think the Board of Trustees guiding principles about engaging stakeholders more, especially law schools, I think probably, yes, all the heads, I think resonates with everyone. Natalie and Teresa and I are planning more law school engagement touch points even outside of the public agendized meetings, because this is a stakeholder group that is of the utmost importance as we move toward whatever we're moving toward with the bar exam. There's no reason for any disconnect between your on the ground and your expertise and the way that the bar exam is going to be shaped in the future. So, and thank you so much, Mary, for volunteering multiple times. You're working with Ken and here in this meeting, so thank you.
Okay. Don't see any other questions. I'll turn it back to you, Chair Iridan.
Thank you, everyone. At this point, I believe we are ready to adjourn. Do we need a motion to adjourn, Natalie?
No, we don't need a motion.
All right. Well, thank you, everyone.
Thank you.
Thank you.
Thank you. Good
Thank
to see you.
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 Bye.